Good afternoon. The House Criminal Justice Committee is back in session. This afternoon we will be continuing to take testimony from interested parties on the juvenile life without parole bill package. At this time, I'd like to call forward, if she wants to go at this point, Oakland County Prosecutor Jessica Cooper. Just hit that red button in front of you.
Mr. Chairman and representatives, I don't think we have anyone left from the Senate, but if they do come, thank you for inviting me here. My name is Jessica Cooper, and I'm here basically at the invitation of Ken Samborski, who will be testifying soon. He is the father of the now deceased Mason Samborski, an Oak Park safety officer, whose act of kindness of driving a 16-year-old allegedly to his sister instead of arresting him for driving without a license was repaid by a bullet to his head at very close range. My very first official act, as a matter of fact, a couple days before I took office, was that funeral. And so that kind of sets the tone of what we have experienced, and we'll talk later. I know that you have some questions about the difference between a prosecutor looking at a case and a judge looking at a case, and that's because I think sometimes we look at it up close and personal, and I hope that you listen very carefully to what the victims have to say here. It may make you very uncomfortable, but think about how uncomfortable they have been through this whole process. I speak to you not only as the prosecutor of Oakland County, but as a former judge. And in the 1990s, when the juvenile statutes were different, I sentenced 2 juveniles in separate but equally heinous cases to first-degree murder cases to life without parole. So I have looked at this as a prosecutor, and I have looked at this as a judge. I have looked at it as an academic. But I don't come to speak to you as a theorist. I come to speak to you as someone who has a lot of experience, and there's a big difference between theory and cold, stark reality. And what you will probably hear this afternoon is a lot of cold, stark reality, and you need to hear it. Now, while you will be discussing many aspects of the United States Supreme Court case in Miller versus Alabama, what we need to understand, and the conversation needs to come back to, is that first and foremost, we are talking about individuals who have been convicted by a jury of the most serious crime on Michigan's books, the crime of first-degree murder. We're not talking about lesser crimes. We're not talking about innocent defendants. We are talking about killers, and these individuals happen to be under the age of 18. And my concern are 2 issues that I'm going to address, and they are a little bit different from what you heard this morning. But my concern is the extension of Miller versus Alabama. The first concern is on House Bill 4806, and it provides that judges be given the option to sentence a juvenile who's been convicted of murder in the first degree to a sentence limited to a set term of years. Jurors sat through a trial. They heard the evidence. They determined that the defendant was guilty beyond a reasonable doubt, not of first-degree murder. They didn't find him guilty of second-degree murder, not one of the 2 manslaughter options, but murder in the first degree. Permitting courts to sentence such convicted murderers to a term of years would literally set aside the verdict of the jury. The jury's made that determination. That determination is not a lesser offense, it's murder in the first degree. And so in order to go forward with that House bill, it's contrary to the holding in Miller versus Alabama. We've heard individuals, and as a matter of fact, it was a defense attorney before lunch who indicated that the choice between that Miller gives you is life with or life without parole. And it gives us great pause and great concern when we talk about a term of years. It's life with or life without. Ellison case, the Michigan Court of Appeals interpreting Miller also indicated it is life with or life without parole. Simple math will tell you that a 20-year sentence or even a 40-year sentence will release a defendant who has been convicted of murder in the first degree back into the community when they're 36 years of age or even 56 years of age. You think they still won't be dangerous? Do you have mechanisms by which the prison system is going to rehabilitate these people? Do you have mechanisms that are available to them when they come out? Everything that we talk about means that something must be in place before you pass this legislation, before you release anybody into society. Now, the second issue concerns ensuring that the judges who make these sentencing decisions, life with or life without parole, of juveniles convicted of first-degree murder, are provided with, and I don't think we're even going to have an issue of dispute of this, that they be provided with objective material to make that determination, objective material, whether it should be life with or without parole. There is no mechanism in these bills to provide for anything other than a pre-sentence report giving the juvenile defendants limited pre-sentence scrutiny. Now, minimally, there should be a requirement of an extensive familial history and a psychological evaluation. These are all referred to in the Miller decision, preferably at the forensic center where people are trained to evaluate the mental culpability of criminal defendants. And such a report would require, and you would need to think about this too, a waiver of the juvenile unprivileged juvenile evaluations and judicial findings. We've placed this decision of life with or without parole in the hands of a member of the judiciary. And we have to give that judge all of the tools and the background information that is available to them so that those judges make an informed decision. So nowhere in any of these packages is there a mechanism. Nowhere is there an issue as to who's going to pay for these evaluations. Are you going to provide for independent evaluations? Who's going to pay for that? And that is a mechanism so that we're talking about something that is near and dear to me both as a prosecutor and as a former judge. How are we going to get enough information, objective information, to that judge to make that determination? Now, I told you at the outset that as a circuit judge, I sentenced two juveniles to life without parole when I sat on the bench. One of those cases involved the co-defendant who was 14 years of age at the time of what was a brutal rape of a woman who was picked at random by these two defendants. And at that time, the statutes required that a 14-year-old be sentenced as a juvenile. And so he was given all of the benefits of the juvenile system, and he was released when he came back and came out as an adult, when he became an adult. But when he was released back into the community, because there was nothing available to him, and perhaps we ought to be looking at what facilities were available in the juvenile system, he killed again. And he's now serving a life sentence along with his co-defendant, only this time he was sentenced as an adult. I have also taken a liberty, you'll have to forgive me, I look at statutes and I see holes in them, so I prepared and attached to my written statement a list of bullet points that list some of the inconsistencies and some of the logistical problems in the bills. I don't want to take up any more testimony time. Some of those are the time limitations in that sometimes you've listed mitigating factors, but not all of them, or aggravating factors, not all of them. One bill says that lying in wait is an aggravating factor, but they don't list poisoning. Okay, and so those are cleanup problems, and we just as I'm wont to do, took some academic liberty and prepared something for you if you wanted to take a look at that. But in conclusion, and I know that you have some questions for me because the Attorney General promised that I was going to say something. I'm not sure that I've lived up to his expectations. But once a jury has seen and heard all of the evidence, and they've made the difficult determination that the defendant has committed the ultimate crime of first-degree murder, I think that we need to be very circumspect before we allow such individuals to be released back into the community. I know that at least in my office, before we even think about a waiver, we sit down with the chief of the juvenile division. We sit down with the chief of the warrants division. These are not decisions that are made easily by a prosecutor. But once that decision is made, it goes to a trial. It goes to a jury. That jury has made that determination. That jury has listened to the evidence. That jury has made a determination of that degree. And the only time that there is life without parole is if there is a finding of murder in the first degree. And when we talk about that first issue, having a term of years, that sets aside the determination of your citizens who sit on that jury. So even with juvenile offenders, and in fact, especially with juvenile offenders, experience has taught us that there is a danger that convicted killers pose to a community, and it's too great an issue to take it lightly. And I'm saying that you have a proposal in there. They're all well-meaning. You're not together on them, but it requires a great deal of thought before we make those type of determinations. I thank you for taking the time. I know that apparently you have a lot of questions for me, but my issues, because I knew that other people would address the other ones, are limited to I'm very concerned when we talk about a term of years. When the Miller decision says life with or life without, I'm very concerned. It is your right to extend that decision, but as I understand your statements where you wanted to be able to have a mechanism by which to comply with that decision. And I hope that you would look very carefully at what we've addressed.
Thank you. Representative Graves.
Thank you, Mr. Chair. Madam Prosecutor, thank you for being here. I always appreciate your input on the issue. During your testimony, I'm not sure I understood, do you see a difference between the, if you will, the trigger person versus person who just happened to be at a B&E inside the home?
I think that one of the distinctions when we talk about prosecution and waivers is, you know, we have all kinds of rumors here. I can only speak for what I do in my office. We look very carefully at someone's culpability before we charge. We also look very carefully, and we literally sit with our juvenile people before we think about a waiver. Sometimes someone who is there might be someone who didn't pull the trigger but was encouraging. We might see someone who was there who didn't pull the trigger but who was the mastermind. Everything depends on an individual case. If you had someone who was simply waiting outside in the car and they're the master, it might be different. And every case is individual, and every case, at least in my office, we look at individually before we issue a charge in terms of culpability.
But isn't that what we're being asked to do now? To look at
no, you're not asked to look at each case individually. That's what you've given the power of the prosecution to do. That's what we hope that the prosecutor understands, that their job is justice and not simply prosecution.
I apologize. Let me rephrase that. We're being asked to let judges do that now, to review each case?
Well, no. Let me back up. Okay, in the 1990s, the statute was such that if a juvenile committed a certain list of crimes, that a probate judge could waive that matter to circuit court. In those times, before prosecutors were allowed an automatic waiver, The circuit judge, and I was a circuit judge at that time, was given the discretion, having heard the case and heard all of the evidence,